Thank you, Wes. Thanks for the introduction. Welcome everyone to the 8th session in the Africa Talk series, organized by the Africa Interest Group, one of the many interest groups at the American Society of International Law. The African Interest Group seeks to elevate the socio-political discussions that foster dialogue and impact the African states, African people, and the diaspora in a positive way. The Africa Talk series was initiated by Mohammed Hillel and I, co-chairs of the African Interest Group in 2020 to maximize the stay at home of most legal professionals at the start of the global pandemic. Interestingly, the Africa Talk series has evolved to an insightful and worthwhile series of sessions. I implore you all to have a look at the past session on ACO YouTube channel. Today's event is co-sponsored by the Human Rights Interest Group and the Transnational Justice and Rule of Law Interest Group. This session is also in partnership with the Law Crest LLP Lagos and Love and Long LLP New Jersey. Today's topic is a call to action, the principles of Martin Luther King Jr. and the modern lawyer. Martin Luther King believed freedom is not an internal phenomenon, it is a communal concern. As Martin Luther King Jr. stated, small daily actions can lead to big changes. If we take action collectively, we can work to make the world a better place. Martin Luther King believed in people coming together to create something great. Today's discussion will have 6 phenomenal lawyers, with the lead speaker speaking for 12 minutes. Thereafter, the 5 speakers will speak for 8 minutes. Then the floor will be open for everyone to interact. Thereafter, we'll have a Q&A session in which the audience, the attendees can now send in their questions through the chat box, and we can comment on, or we can respond to the comments sent in. The lead speaker, Chris Campbell. Chris Campbell is a US attorney admitted to the South Carolina bar. He has an LLM in Chinese law from Tsinghua University, China, and holds a JD from the University of South Carolina. Chris is an international arbitrator, an international mediator, and counsel. He has worked in China, UK, Italy, and Portugal. Chris is a senior counsel litigation at Baker Hughes. It's my pleasure to welcome Chris Campbell to open up the conversation. Thank you.
Thank you for that, EJ. Good afternoon, ladies and gentlemen. As Ijeoma has so wonderfully said, my name is Christopher Campbell, and it is my esteemed honor and privilege to be with you today as I begin and dedicate my remarks today to 2 individuals, both who have tragically lost their lives in the past 17 days. First, the brother Amir Locke, who was the victim of a broken law enforcement system which stubbornly refuses to acknowledge its failings and shortcomings, even as another Black body lays at its feet. Brother Block was a mere 22 years old, and like many of those across the United States, he was guilty of only one thing, LWP, living while Black. He was sleeping on his couch with a legal firearm on his person and was errantly gunned down by police serving a no-knock warrant that did not bear his name. He is gone too soon, and he was denied his right to life and stripped of the very fundamental guarantees as an American citizen. The second person was a teammate, friend, and colleague of mine, Miss Chesley Christ. Cece, as many that knew her well would call her. She was a Miss USA, a businesswoman, an athlete, a lawyer, and a fierce advocate for the oppressed and the underrepresented and disenfranchised, both in the United States and abroad. Chesley was also a sister, daughter, and so much more, including a source of inspirations for millions of people across the globe, including myself. She was a brilliant and beautiful soul that is now gone too soon, and also the victim of society and a healthcare system that does not support its people of color, and in particular, its women of color. Though my heart is broken and devastated for these losses of these 2 wonderful lives, I'm reminded of the words of 2 Corinthians 5:8, which in summation says, "To be absent from the body is to be in the presence of God." Now, Despite that melancholy opening, surely you did not think that you would come to a talk on the life and legacy of Dr. Martin Luther King Jr. and think that you weren't going to get a little bit of word. And it is that spirit of that word, which I believe can be found by many names and by many ways around the world, that I find the theme of my comments today, the singular theme of my remarks, the ultimate legacy of Dr. King, and what I pray will be our guiding star as global citizens, as jurists, and as people. That is Black love. But before we talk about this critical subject of Black love, allow me to greet you properly. I speak to you today across the sea in the tradition of the giants that came before me, James Baldwin, Maya Angelou, and Frederick Douglass. I am seated in Florence, Italy, a foreign land, yet today it is my homeland, from the sparkling shores of my beloved South Carolina to the craggy coast of California that is on my mind. The people that live there, their state of mind and well-being and the future that they hope for and that we must work for. It is fortunate to realize that that same love that I have for my people still in the United States extends to all people everywhere of all backgrounds and creeds. This too is in the legacy of the Dr. Martin Luther King Jr. Dr. King was a great many things: a minister, a father, a husband, a leader and tireless champion for human rights. While he may never have sat for the bar, by his rhetoric, impact on legal policy, and bearing the burden of the advocate, it could be said that he practiced in a way that most jurists could only dream of. His life and legacy lives on in each and every person affected by his actions, and perhaps most clearly in his role in the passing of the Civil Rights Act of 1965, which outlawed the discriminatory voting practices adopted in many Southern states in the wake of the Civil War, including literacy tests as a prerequisite to voting. This achievement was the ultimate culmination of Black love, a love that endures the hatred of bigotry and the discrimination that shouts, "You don't belong," a love that sacrifices itself for justice, for a brighter and better future. That is Black love. 100 years after the final cannons of war had stopped ringing, nearly 250 years after the first enslaved person arrived in these United States, Black Americans had their rights as legal citizens recognized by the laws of the country they had endeavored to protect. In this moment, and in a manner that the United States still pursues, at some times more earnestly than others, the United States answered the call of its Black citizens to honor the words from its founding documents that all men are created equal. Now, I wish that I could tell you that was the end of the story, that Black love had won the day, and that the Americans had realized the dream of Dr. King. I am so sorry to report that I cannot. In fact, I come with a dire warning about the forces that would return the United States to where it stood some 60 years ago, in the wake of the greatest civil rights movement since the time of Dr. King, and in the aftermath of defeating an American dictator. Regretfully, nearly 20 states have sought regression of civil rights and effectively erasing the legacies of heroes such as John Lewis, Rosa Parks, and the Honorable Thurgood Marshall, and yes, indeed, the legacy of Dr. King. These states, like their forefathers and like the framers of the Constitution, and even the legislative Klansmen during the Reconstruction through to Jim Crow and on to 2020, seek to do the same thing. That is silence large swaths of the American population for the sake of consolidating wealth and power in the hands of a few. What's worse, they attempt to legislate collective amnesia by erecting the boogeyman of critical race theory as an affront on America, which they only perceive as having certain people, when in reality, critical race theory is nothing more than the mirror of history shown to the face of American citizenry and its government. These lawmakers have learned to remove overt discriminatory language such as Negro and colored in their lawmaking, which they levy with such surgical precision and provides the thinnest veil of neutrality and colorblindness. Well, let me tell you, my brothers and sisters, Black love is not blind. Black love is Souls to the Polls. Black love is Stacey Abrams, Deborah Scott, and Tamika Atkins, organizing our communities and enduring the most dogged attempts to break our will and persevering to love each other, to love this country, and to fight back against tyranny. So then, what can we do? To answer that question, we must first understand the battlefield on which we stand. We must reflect on the role we are willing to play and what role we can play in this march for equality and justice. As history often does, we can look to recent historical examples for inspiration and guidance for how to effectively wage campaigns, strategic strikes, and political movements. When we manage the civil rights movement, when we imagine the civil rights movement, we can visualize the large crowds, marches, clashes with law enforcement and counter-protesters, and violence against unarmed individuals. We can hear their voices chanting, singing, and demanding justice. They provided a literal manifestation of the will of the American people. Then we can imagine the community organizers who were both organizers of large crowds that would help set up bail funds, and they would speak to the media, conduct trainings on how to survive in the face of violent oppression, and pressure their elected officials. In addition to these two broad categories, we have those who played critical roles behind the scenes, financiers of these operations, strategists who would plan and coordinate offensives against these unjust policies. And finally, and for purposes of this explanation, we had the lawyers. As the smoke was clearing over Europe from the Second World War to this very day, lawyers have played a critical role in the fight for justice, filing lawsuits, attacking legislation, drafting amicus briefs. In other words, using their training, their skill sets, and resources as lawyers to support the movement in the streets and to force resolution of fundamental injustice. Now, the United States Supreme Court decision in Shelby County v. Holder is Plessy v. Ferguson for a new generation. It was issued back in 2013 and laid the groundwork for a modern version of separate but equal. It held that because the data used as the foundation of the Civil Rights Act was now over 40 years old, that there was no longer a need for federal oversight in states with a historical record of racially discriminatory voting policies. Of course, what we saw was the appearance of laws across much of the American South designed to silence and infringe upon the rights of ethnic minorities, and in particular, Black people across the states. So it is no surprise that in the wake of the 2020 election, that these forces focus on how the voting rights can be changed so that less Black people vote. Now, understanding the history and the context in these final couple of minutes, and before inviting my brothers and sisters to kick off what I'm confident will be an enlightening panel discussion, let me end with the good news and the things that we must do, the things that we are listening to, and that we must do in order to uphold our oaths as lawyers to protect our Constitution and our civil liberties. First, organize, gather together with 2 to 4 like-minded lawyers and commit to engaging with an organization that is working to protect civil rights. Amongst yourselves, decide what roles you will play as a strategist, one writing content, supporting FOIA requests, or defending and fighting legal cases against activists. 2, donate. If you have the means or the funds, identify organizations that are doing the work. A few suggestions might be the NAACP Legal Defense Fund, Black Lives Matter, ACLU, and especially one category that is often overlooked, bar associations, whether it be the ABA, your local bar, or similar organization. They have task forces or initiatives dedicated to addressing these issues. And if they don't, then now is the time and the opportunity to do so. And finally, another under-discussed issue is the waning numbers of Black lawyers. It was about 6% or so when I was in law school, briefly jumping to 8%, but it's dwindled down back to 4.7%. 4.7% to represent the needs of Black clients. And as a member of that same community, it is woefully insufficient, especially considering that Black Americans represent about 12% of the population. Simply, if there are not lawyers in these communities to pave the way and to offer a helping hand, then the Black community, and really any community, is left vulnerable to those who would infringe upon their legal rights, as we have discussed today. It is, of course, important to be a role model and to be available to talk with these junior lawyers and students, but so too, it is incumbent upon us to create opportunities for them to open up space in our organizations and to let those Black voices have a chance to join the conversation. In conclusion, love is patient, love is kind. It does not envy, it does not boast, it is not proud, it does not dishonor others, it is not self-seeking, it is not easily angered, and it keeps no records of wrongdoing. But it rejoices in truth, it bears all things, believes all things, hopes all things, and endures all things, and love never fails. These words from 1 Corinthians 13:4, I believe, are the essence of Black love. For people that have endured many hardships in these United States, yet still have the audacity of hope to believe that there is a better way, a better future, and a better life, but only if we are willing to struggle and to fight for it. Previous generations have done that. And in the decades since, we have walked on the momentum of their fortitude and spirit. So now is the time has come that we must take up the mantle and go forth for ourselves, for our children, and in the path of this address's namesake, Dr. Martin Luther King Jr. Indeed, the time is always right to do the right thing. And the people said, amen.
Amen.
It felt like a church service. Thanks for that, Chris. Thank you. It felt like a church service. Thank you. Our next speaker is Eunice Shang-Simpson. Eunice is a solicitor advocate admitted to the senior courts of England and Wales. She has an LLM in international law and international commercial law from the University of Kent. Eunice is pursuing a PhD at the Canterbury Christ Church University. She is an international arbitrator, an international mediator, and counsel, a council member of the Law Society of England and Wales. It's my pleasure to welcome Eunice Shang-Simpson.
Thank you, EJ. Can you hear me?
Yeah, we can hear you loud and clear. Thank you.
Right. So, thank you, EJ, and thank you, Asil, for inviting me to speak here. My name, as you heard, is Eunice Shang-Simpson. I'm an international arbitrator and a council member for the Law Society of England and Wales. What you may not know, however, is that this has not always been my story. I spent over 15 years as a specialist CPS prosecutor in a job that I absolutely loved. I was able to work at Eurojust in The Hague, at our international division in London, until one day, completely out of the blue, I was told that my division was being moved to a different county, which would have meant a 6-hour round trip commute, which I was not prepared to do. So in 2015, I found myself accepting a leaving package, way too young to retire, but totally unprepared for the big, scary world out there. Talk about midlife crisis. I'm sure some of you resonate. Well, after taking some time out to feel very sorry for myself, I decided to do the next best thing I could think of, which was to use part of the package to study for an LLM, little knowing how that would change my life. Because it was during my studies that I met a lecturer who introduced me to ADR, and arbitration in particular, and encouraged me to study to become a fellow of the Chartered Institute of Arbitrators. That was just a distant dream at the time, because lots of people were quick to point out to me that with only criminal prosecution experience, my dream to be an international arbitrator would most probably remain just that, a distant dream. I persevered, and because I didn't have a full-time job, I was able to devote some time to giving back as a Law Society committee member and now as a council member of the Law Society. I was also able to give back as a trustee of AFAS, which is the Arbitration Fund for African Students. And I also realized my dream of becoming an arbitrator. So, last year, I was appointed as a member to the Icc Africa Commission, and I also get invited to speak on panels such as this. I say all this to underline the fact that it is not what life throws at you, but what you decide to do with your dream that defines you. When I was preparing for this, obviously we all know about Dr. King's famous "I Have a Dream" speech. It got me thinking about another dream I have, that of helping African states redefine sovereignty on their own terms. Because whilst political independence is great, I believe the real test of sovereignty is regulatory and economic independence, but that's perhaps a conversation for another day. What I would like to talk about now is Dr. King's letter from Birmingham. Now, shout out to my buddy Tom, who introduced me to this letter. Thank you, Tom. On the 16th of April, 1963, whilst confined in the Birmingham City Jail, Dr. King wrote to some fellow clergymen who had put out a statement calling his activities unwise and untimely. I will highlight a few of the principles that Dr. King set out in that letter and explain how relevant they are to us as modern-day lawyers. Firstly, Dr. King stated that he was in Birmingham because there was injustice there. He goes on to state that he is cognizant of the interrelatedness of all communities and states, and that injustice anywhere is a threat to justice everywhere. He concludes that we are caught in an inescapable network of mutuality, tied in a single garment of destiny. Whatever affects one directly affects all indirectly. That has never been truer than in these modern times where the world is becoming a global village. We as lawyers must be aware that it is our responsibility to lock arms with our colleagues around the world to fight injustice wherever it appears and in whatever guise it is presented. Secondly, he points out that none of the gains made via the nonviolent campaign were made without determined legal and nonviolent pressure. He says that lamentably, it is a historical fact that privileged groups seldom give their privileges up voluntarily. Freedom, he said, must be demanded by the oppressed, and that the concept of wait has almost always meant never. And that since justice too long delayed is justice denied, I would suggest that it is the responsibility of each modern day lawyer, using all the legal skills we possess, to ensure that we take steps to uproot systemic racism, inequality, barriers to social mobility, and barriers to access to justice wherever we come across them, without falling into the trap of waiting for the time to be right. As he points out, there is nothing new about this kind of civil disobedience. He references this in the refusal of Shadrach, Meshach, and Abednego in the Bible to obey the laws of Nebuchadnezzar on the ground that a higher moral law was at stake, and also in the actions of early Christians who were willing to face hungry lions rather than submit to the unjust laws of the Roman Empire. Although regrettably, there are still some parts of the world where lawyers are in danger of losing their lives for upholding justice. For the most part, the modern lawyer does not face that dilemma, but it still behoves us to use our time and talent wisely and to believe that the time is always ripe to do the right thing. The third principle from Dr. King's letter that I wish to highlight is his frustration with people who he felt should know better and therefore should do better. He writes, I quote, "I have almost reached the regrettable conclusion that the Negro's great stumbling block in his stride towards freedom is not the white citizens' councillor or the Ku Klux Klaner, but the white moderate who is more devoted to order than to justice, who prefers a negative peace, which is the absence of tension, to a positive peace, which is the presence of justice, and who constantly says, I agree with you in the goal you seek, but I cannot agree with your methods of direct action." Dr. King concludes that generations will have to repent not just for the hateful words and actions of bad people, but for the appalling silence of good people. The Icc Africa Interest Group seeks to elevate the socio-political discussions as they pertain to Africans, African-Americans, and Friends of Africa, as EJ says. So I invite all Friends of Africa to align themselves with this call to action, because we are all in this together. And to quote Chase Jarvis, one of my favorite podcasters, a rising tide lifts all boats. In conclusion, as a final call to action, I would invite us all to consider ourselves as extremists and even embrace the label. To quote Dr. King once again, was not Jesus an extremist for love? Love your enemies, bless them that curse you, do good to them that hate you, and pray for them who persecute you. Was not Martin Luther an extremist? He said, here I stand, I cannot do otherwise, so help me God. And John Bunyan, who said, I will stay in jail to the end of my days before I make a butchery of my conscience. So the call to action is not whether we will be extremists, but what kind of extremists we will be. Will we be extremists for the preservation of injustice or for the extension of justice? I can confirm that at the Law Society, we continue to fight for access to justice and legal services across the board. and we fight for endangered lawyers in other jurisdictions and fight to achieve social mobility in the legal profession here. At the Icc Africa Commission, I can confirm that we have detailed plans for our term of office to elevate justice for all. I personally intend to follow in the footsteps of Dr. King by continuing to dream big dreams, regardless of what life throws at me, and to be an extremist for the extension of justice. And I encourage you all to do the same. So please feel free to connect with me on LinkedIn so that together we can keep Dr. Martin Luther King Jr.'s flame alive. Thank you.
Thank you, Eunice. Thank you. And thanks for the quote. It's not what life throws at you, it's what you do with what you have. I love that quote. Thank you for that. Our next speaker is Rose Rameau. Rose Rameau is a civil law and common law lawyer. She's licensed to practice law in Paris, France, Washington, D.C., Florida, New Jersey, and a barrister and solicitor of the Supreme Court of Ghana. She has an LLM in French, European and International Business Law from University of Pantin-Assas in Paris. She holds a JD from Syracuse University College of Law in New York. She's an international arbitrator, an international mediator, and counsel. Rose is the managing partner at Rameau International Law. It's my pleasure to welcome Rose Rameau.
Thank you so much, EJ. Hello, everyone. I hope we have all had a great start for Black History Month. Ijoma, I really appreciate your introduction and thank you for planning this exceptional event. I think that events such as this one are extremely important, and the fact that we have so many people who sign on to be here with us is a testament of its importance. So I'll say a few things about Dr. Martin Luther King, but it's very hard to speak after these two distinguished speakers, but I'll do my best to fit myself into these shoes. Dr. Martin Luther King Jr.'s name is known all across the world, and his name has become synonymous for freedom, synonymous for justice, synonymous for equality. But what I've realized that we rarely study his principles. And my sister Eunice touched up on a few principles, but that is really, we rarely study how did he really fight for freedom? How did he fight for justice? How did he fight for equality? And his approach to creating a better country, a better United States, or really a better world for us all is just as important as what he stood for. First, let me say, as my brother Chris mentioned, MLK, Martin Luther King was a Christian. And so am I. I'm a proud Christian. So Martin Luther King was also a minister. And when I hear Chris talking, it's just like I see the minister, and I'm always amazed by his ministerial capabilities. So whatever Martin Luther King did, because of that background, truly affected every action that he took. So I'd like to take a close look today at his principles and pinpoint how they are applicable to the modern lawyers today in 2022. Martin Luther King had 6 principles. The first one is he believes that nonviolence is a way of life for courageous people. Number 2, he believes that nonviolence seeks to win friendship and understanding. Number 3, he believes that nonviolence seeks to defeat injustice or evil, but not people. Number 4, he believes that nonviolence holds that unearned voluntary suffering for a just cause can educate, transform people and society. Number 5, nonviolence chooses love instead of hate. Like my brother Chris puts it beautifully in his introductory remark. And finally, he believes that nonviolence believes that the universe is on the side of justice. Now that's a big one. I will not go over all 6 of them, but I will just highlight a few. But for all of us on this webinar today, I would strongly encourage you to read about all the 6 principles, because today they are still applicable and we can still move forward. We can still follow those great principles for our lives. So I start. The first one I'd like to talk about is the principle that nonviolence seeks to defeat injustice or evil, but not people. So in other words, the fight should never be between us. It should be the thing, the injustice and the evil. This is such an interesting principle. It's so interesting, especially in the wake of what we now call cancel culture. It is so easy to cancel people. And sometimes it could be even necessary. But I put to you today, we shouldn't mistake canceling people for progress, nor is canceling someone always the answer. I think that we often take the side of an eye for an eye. We focus on punishment. This wouldn't be aligned with Martin Luther King's principle. I believe that the modern lawyers, as modern lawyers, we should seek to rehabilitate. Rehabilitation and conciliation should be what we look for. That is what I believe that Dr. King would probably do. He would promote dialogue, he would promote rehabilitation and conciliation, and that would be a key to defeat injustice and evil, and not each other. For instance, I'll tell you, as a mediator, also as an arbitrator, but more so as a mediator, I am faced often with 2 distinct parties who are polarized, okay? And the only way forward sometimes is to reestablishing the trust, so that put the parties back at the first time when they first signed this wonderful agreement to do business. And once you can establish that trust, you see people can talk again. So I think that's a very important principle for us to think. Martin Luther King was always open for the dialogue. So the second principle I would like to highlight for the modern lawyer is the principle that nonviolence is a way of life for courageous people. Courage, that's a big word. I remember having a student in my early days of teaching in New York City. His name was Courage, and he was from Nigeria. I love that kid. I love to say his name because he carried that name. Everything that he did was with so much courage, so much power. And to steal my sister's word, extremists of courage. And it was so beautiful. And I think that today, the word courage, we are lacking that. In some cases, it's really as simple as, I'll say this, see or hear something wrong, do or say something right. It sounds easy, but you'll be surprised to see how often people would rather stay quiet in the face of injustice. They know it's wrong, they'll stay quiet, just so that they could feel comfortable, just so that they could fit in, just so that they are invited to the club. That wouldn't be MLK. MLK would ask us to be courageous, to speak, to say something positive and not negative, not to fight with an eye for an eye. So by virtue of being a lawyer, we have privileges. One of the privileges is that we have a sound legal education. And what do we do with the privilege? And some of us have even more privileges. I sincerely believe that it is the modern lawyer's responsibility to use all his or her privileges to enact changes. So the modern lawyer's motto should be, I see something, I hear something, so I'm going to do something right, not wrong. We do not fix a wrong act with another wrong act. That's what MLK would tell you. We must not give up. We must use our voice. Your voice matters. your opinions matter and you can make a difference. That's why I think the third principle I'll go over today is finally one that's also important, is the principle that nonviolence, Martin Luther King believes that you are on the side of, the universe is on your side when you are fighting for justice. So nonviolence believe that the universe is on the side of justice. So anytime you may feel so cowardly, you don't want to speak up, or you feel you're so small, your opinion won't matter, you can just remember one thing. If you're acting on the side of justice, the universe is on your side. So if God is for you, who can be against you? If you're acting on the side of justice, the universe is on your side. Dr. Martin Luther King would probably say that God is a God of diversity because he created all of us. So when you stand to promote equal justice under the law, you know that the universe is on your side. Fear nothing. And Martin Luther King paid for the price. He did not fear, he fought. And just think about how much we've gained so far. Think about how far we've come since Martin Luther King's death. And he even died before we established the first Black History Month. Now it's a very small little details, but the point is we have made some progress, but we have a long way to go. Everyone here has an opportunity to do something. Everyone here has something they can bring to the table. We must work together. We must listen to each other. We must allow each other, whoever would have made a mistake in the past, we must allow them to be rehabilitated and not be shunned. We must not be so quick to cancel them. Just because you don't think like me doesn't mean I should just erase you. Maybe dialogue, listening to you, that could bring us back to the table. And finally, as my brother puts it, access to justice. Access to justice for the modern lawyer. You know, I'm an arbitrator. I stopped doing criminal law like Eunice did years ago. There are many things I stopped doing. So I think, what is it that we do in dispute resolution that I could still say that the modern lawyer can actually advocate for access to justice? It means the creation of other means of resolving disputes. The alternative ways to provide access to justice indeed is the creation of safe spaces for us to have friendly and mature dialogue without going to court. My brother Chris created one of those beautiful spaces. And I think it's very, very important. Sometimes all that may be needed is an apology. And sometimes you don't even need to go to the court. It's just to be able to look at your brother in the eyes and say, you harmed me. This is how I feel. And for the other one to answer, oh, I didn't think so. I am sorry. And that can keep us out of the courtroom. So I applaud you and I encourage you to think about all different ways we can fight, we can uphold Martin Luther King's principles. Thank you.
Thank you, Rose. I didn't know you had 6 principles. I'm going to go back and read about them. Thank you for that. Thank you so much. Our next speaker is Nancy Savan. Nancy Savan is a U.S. attorney admitted to the New York Bar and Florida Bar. She has an LLM in French legal system and European community law from University of Paris at Panthéon Assas, Paris. She holds a JD from Tulane Law School, New Orleans. Nancy is an international arbitrator, an international mediator, counsel, and an adjunct professor of law. She's the founder and managing partner of Thevenin Arbitration. Nancy is the general counsel of the United States Council for International Business. It's a pleasure to welcome Nancy Savan to speak.
You are muted. You are muted.
I wanted to say thank you very much, EJ. one small correction. I would love to say I have an LLM, but I did not. I went to law school. I think I was one of the first classes that was allowed to go to law school while in France while I was in law school in New Orleans. So I was able to study at Panthéon-Assas, which is also known as Paris 2. Okay, I'm gonna go to this. So good afternoon, everyone. First, I want to thank the American Society of International Law's Africa Interest Group, and of course, EJ, thank you so much for the invitation to address you all of you this afternoon in discussing Dr. Martin Luther King's legacy and how we as lawyers can implement the principles he espoused. Second, as EJ mentioned, I serve as an international arbitrator and mediator based in New York, whose focus practices mainly in Latin America and the Caribbean. I also serve as an outside general counsel for the United States Council for International Business, otherwise known as ICC USA. My remarks here are mine alone and are not those of the organization with which I work. That said, Eunice just quoted from Dr. Martin Luther King's letter from Birmingham, that injustice anywhere is a threat to justice everywhere. And it is in that context, I will address the three main points or themes that from Chris's earlier presentation, and that is access to justice, to framing inequity, and three, using legal tools to uproot injustice. I will do this in the context with which I am most familiar, and that is international arbitration, and especially from a US perspective. Let's take access to justice. What we have in international arbitration is a perception of a lack of access to justice and economic justice. Two principles that Dr. King championed, and the latter especially, he didn't champion the lack of. He fought against the fact that there was a lack of access to justice and economic justice for all, we should say. The latter, economic justice, is something that Dr. King especially fought for poverty, looking at the world and seeing the effects of injustice, economic justice globally, was something that Dr. King, especially in his latter years, fought against and was protesting against up to the time that he passed, or was assassinated, I should say. So let's talk about ADR and how those two principles can be reviewed when we look at an ADR, especially as it's practiced in the US. Okay, so it's undeniable that ADR, including arbitration, is increasingly becoming the preferred means of resolving commercial disputes. In fact, in the US, it's unavoidable, from contracts between businesses to contracts with consumers. Society is increasingly faced with having disputes resolved through arbitration. While touted for its many benefits, example, faster, cheaper, flexible, and with experienced decision makers, a few years ago, the parties involved in this growing system came to a major realization. The decision makers did not much look like the people whose disputes they were being asked to resolve. Why is this a concern, especially in arbitration? That's because the other system for adjudication of rights, non-consensual is litigation, right? Where you have a third party making a decision for you, as opposed to mediation, negotiation, and other types of ADR where the parties come to a mutual agreement. So in litigation, disputants are often before judges who don't resemble them in any way. True. Despite the discomfort with that situation, it is not an exaggeration to characterize the same factor in arbitration as being intolerable to disputants. Ironically, this sentiment arises out of an essential characteristic of arbitration, and that is party autonomy. Although an adjudicatory process resulting in a decision by third parties, right? Arbitration is party-driven, we've all learned that, and party-controlled. It is party-driven in that it arises from a consensual act and agreement to arbitrate. It is party-controlled in that while operating within an agreed framework, it nevertheless allows the parties to design a process that best suits their needs. Despite these characteristics, however, an axiom in arbitration is that the quality of the proceedings will often depend on the caliber of the arbitrator. Even further, in a 3-member panel, while not expected to advocate for any particular side, a party-appointed arbitrator is expected to present that party's perspective on the tribunal where needed. This is especially the case in international arbitration, where the parties often come from different cultures. For a party-driven and party-controlled system, therefore, the persistent homogeneity of arbitrators, that is, same gender, age group, education, culture, that ignores the growing diversity of the global business community engaged in commerce is increasingly becoming untenable. In fact, it presents an existential problem for arbitration itself. Because, and I'm quoting from an article, because arbitration is often used as a substitute for the judicial process, ensuring that decision makers are representative of the diverse group of individuals before them is key to ensuring fairness and public justice, as well as ensuring that disputants will accept and abide by the arbitrator's decision. Having a group of arbitrators that is diverse is essential for democratic representation of the parties in disputes and helps to ensure that all of the parties have a fair chance at justice, right? Now, there's been several studies that have talked and touted the benefits of diversity. Aside, but especially in ADR, arbitration and ADR, especially aside from a perception of a fair and just process, the benefits of having diverse arbitration panels are well documented. Namely, diverse panels provide a variety of perspectives, bringing people together with different problem-solving skills, leads to less gender-biased decisions, and provides a holistic approach to dispute analysis and resolution. In sum, aside from the enhancement to the dispute resolution process that having a pool of neutrals of different genders, ethnicities, and cultural backgrounds brings, diversity is crucial in arbitration and ADR, and especially in arbitration, because parties have waived their rights to resolve their disputes in courts. Parties who have waived their rights to resolve their disputes in courts need to perceive that they're involved in a fair and balanced process. Now, we know it's the system that we have is not quite fair. How do we frame it? Framing the systemic inequity, because we sort of need to address it. What has been going on? Until recently, when one spoke about diversity in arbitration, the reference was mainly to gender and generational diversity. Although much work remains to be done, gender diversity is being addressed to the point that we now have the Equal Representation in Arbitration Pledge. And I'm happy to say that I'm one of the US representatives of the pledge. The pledge seeks to increase in an equal opportunity basis the number of women appointed as arbitrators in order to achieve a fair representation as soon as practically possible, with the ultimate goal of full parity. Signatories of the pledge commit to work towards gender parity when organizing arbitration conference panels, committees, or governing bodies, arbitration tribunals or rosters, arbitral appointments, as well as support and encourage women in the industry. While not a cure, the pledge, along with concrete efforts by arbitral institutions and key organizations such as Arbitral Women, have helped improve the percentage of women servers and arbitrators. And I'm describing this because I am going next to talk about what is not being done for an even bigger issue in international arbitration as it is practiced in the US. Today, however, when we speak about diversity in arbitration, we are also referring to ethnic, racial, and cultural diversity. Such diversity must necessarily be defined in its local and regional context, right? So I'm in international arbitration. If I come to the US, I must understand what it means to have a lack of diversity, which might be different if I go somewhere else around the world, say, Poland, for example. So in the US specifically, as demonstrated by the JZ arbitration, and I'm not going to go into the JZ arbitration, but I do have a paper on this, so let me know and I'll be happy to share it. Arbitral institutions will have to address the lack of African Americans specifically on their rosters, whereas in other countries, this may be other minorities or ethnic groups. the lack of ethnic, racial, and cultural diversity is a special concern in international investment arbitration contexts. This is where investors, mostly from the Western world, are bringing to arbitration many countries from around the world, many of whom are from Latin America and increasingly Africa. So lesser developed countries as defined on an economic basis, which in ISDS, known as, while global, it stubbornly clings to arbitrators who are predominantly from the United States or Europe. Internationally, therefore, the problem is so stark that it is a contributing factor to shaken confidence in the efficacy and fairness of investor-state arbitration, which is a big deal, especially for businesses that transact abroad. So the issue of the lack of diversity in our profession is serious, it's real, and it is time to do something about it, which I'm very happy to be living in these times where all of us have an opportunity to put our hands together, our minds together to do something about it. The last thing was legal tools to uproot injustice, right, in this system. I'm going to change it to data to uproot injustice. To gain the recently observed success, for example, of increasing gender diversity in arbitration, the international arbitration community, all of us that are part of it, we have to acknowledge that the lack of racial and ethnic diversity is a problem. And we still have many people who refuse to see this. We have to diagnose its causes. And that is incredibly hard to do. Even while I'm saying it, we have to diagnose its causes. Why are there, for example, in the US, so very few African Americans in this system, especially males? And then we have to gather together to address these issues effectively. So how do we do this? Should be noted here that after much debate, the community, a lot of us, many of us here on this panel agreed that while parties played a major role in the selection of arbitrators, a lot of the burden can be borne by the arbitral institutions to help increase diversity. Who should they should bear the primary burden, right? Not that we are out of it. Parties, for example, and counsel, but the arbitral institutions can play a key role, and that is through the appointment of arbitrators and through their statistics to provide us with information. So even if you believe or don't believe that there is a problem, through statistical data, we can see a lack of representation. Through statistical data, we were able to see clearly that there were a dearth of women serving on panels. And also that affects our ability to earn an income in our profession that we love and have devoted many hours, sweat and tears to develop. So right now I'm focusing on how the arbitral institutions are the best place to give us the data that we need to address the problem. So after years of effort, we've seen that mobilization of every actor in the industry, and that is arbitral institutions, that's what we're gonna need to do, organization, academia, practitioners, arbitrators, and parties, we're finally beginning, right, to see an increase in gender diversity in arbitration. This improvement has been slow, it's new, so the industry has to remain vigilant, yeah? We're not saying they have to turn their attention, because that is another pressure point. If you say you must focus on diversity, gender, generational, racial, sexual identity, there's a perception that, oh, we can't handle all these problems at once. We have to, because we are a diverse group of people. So despite the efforts of the gender in the fight for gender diversity in arbitration, so we're looking at what has been done and how successful it has been, gender diversity can be seen as a low-hanging fruit, especially in comparison to increasing other types of diversity in arbitration that I just mentioned. While the problem and its causes may be similar, how we address it presents challenges for all of us, especially in an international context. So nevertheless, with the experience garnered from efforts to improve gender diversity in arbitration, there's a real hope that increasing other types of diversity can also be tackled in a systematic and effective way. And to conclude, I'm going to refer back to the excellent suggestions that Chris gave in the beginning in getting active and all the lists that he provided in donating. And Chris, I wasn't aware that there was such a low number of African Americans going to law school, but that is something I'm going to turn my attention to as well. So my call to action to you is to get active, get involved in all of these efforts that are out there. And I've heard Chris's call to action and I plan to comply. Thank you very much for your attention.
Get active. Thank you very much, Nancy, for that. Thank you for the interesting and informative session. The next speaker is Lisa Love. Lisa Love is a U.S. attorney admitted in New York. She holds a JD from Georgetown University Law Center. She's an international arbitrator, an international mediator, and counsel. Lisa is the managing partner of Love and Long LLP, with offices in New York, New Jersey, and Philadelphia. It's my pleasure to welcome Lisa Love.
Good afternoon, and thank you so much. I want to extend my regards to ASIL and EJ and all of the others who are on the panel. Thank you so much for inviting me to participate. As my background, you know, one thing that it was very resonates with me about this entire program is that, and I smile because you can't get a lot of diverse people together and us not talk about God. That's just in our nature. So I see that prominently, and you know, that's where we're coming from, because it just takes that kind of eternal optimism, faith, and hope that keeps us taking one step at a time and continue to make progress.
You're muted. You're muted.
You've gone on mute.
Sorry, I thought it was mine.
Okay, I don't know what part you missed, but I'm a member of the African American race. I have been a part of a community that has been subjected to 12 generations of slavery. Most of us can't even think of 3 generations back. If you can think of your great grandparents or anybody in that generation, then you have a long memory. So imagine having to go back 12 generations of slavery, and approximately, depending on how you count it, 8 to 12 generations of Jim Crow. And some may say that that kind of environment still exists in the United States. I'm a parent of children who, you know, Black males who still to this day are continuing to try to succeed in life and are faced with the type of discrimination and things that they have to endure as Black males in this community. I am a wife of a Black male who to this day, even living in a diverse community, will not go to the front door if a police officer comes. He sends me, because they will not think that he lives here. They will think that he's the intruder. So even to this day, he does not go to the door. I am the daughter of a mother who attended a HBCU, Fisk University, in the 50s, when Black people were not permitted to ride in the ambulance to the hospitals. And so it resonates with me more than it resonates with her. But when she got sick during her time at Fisk, she rode to the hospital in a hearse. And even though it brings tears to my eyes, It's indicative of the optimism and the perseverance of my parents. Then when my mother reflects on that situation, she said, Lisa, I looked out the window of that hearse and I realized I was still alive. So, that I come standing on the shoulders of all those who've come before me. Yes, I am an international arbitrator. Yes, I went to Georgetown, and yes, I quite frankly, I can say I stumbled, but then again, of us, as we talk about our religion, we know that there are no mistakes. I've come into the profession of an arbitrator based upon the experience that I had and some opportunities that were provided to bring people of more diverse backgrounds into the international arbitration space. And currently, I am a member of the Chartered Institute of Arbitrators, I should say a fellow, as well as a member of their professional conduct committee. So as that is background, that's who I am. And I put all of that on the table so that you can understand a little bit about my perspective. And I'm sure that each one of us here have a story. When I was asked to reflect a little bit on the call to action, I was brought to memory, August, was it 23rd, 28th, 1963, on the I Have a Dream speech at the Lincoln Memorial. And I'm from DC, so I was in DC, believe it or not, on that day. I think I remember the March of 68 more than 63. But I remember, and looking back on that speech, I know that Martin Luther King emphasized his belief that his movement, the movement, would create a society where character rather than color prevailed. But before I even went to delve into that much, I sort of had to think about Martin Luther King and what I knew about him and how much, how prolific he was. And as much as a reader as I am, how much of his writings had I really read? Did I read in 1958, or what he wrote in 1958, The Stride for Freedom? Have you read The Measure of a Man, 1959? Have you read A Gift of Love, 1963? Or Why We Can't Wait, 1964? Or Where Do We Go From Here, 1967? Or Conscious for Change, 1968? I think all of us, if we reflect on it, we have some work to do. We have some work to do. So I encourage you, as I encourage myself, as I reflected on MLK, that I have some work to do, and we all do. So as you have some time, in the next months, years, reflect on Martin Luther King and go back and look at some of his prolific writings. So as I focus on the call to action and the characterization of people to be recognized for their abilities as opposed to their color, I focused on really three things. And one thing I focused on was consciousness. And I think that many of us who are diverse probably are conscious of the discrimination that exists in society. However, some of us who are non-diverse do not have that same consciousness. So my first call is to develop a consciousness, to recognize your ethnocentricity, recognize that you may have come from a Southern, segregated, all male, affluent community, as one person recently told me that he did, and how his job was really, at this point in time, his first step was to develop a consciousness. And so I ask each of you to really develop a consciousness about race relations in the United States and the history of it, and the 12 generations of slavery. And when you're faced with situations that may say diverse, or they may say affirmative action, you won't have a response as to why do we need that. So the first thing is consciousness. The second thing is community. Often all of us on this call, and a lot of the circles that we run in, we have many choices that we can make. We can choose to send our kids to Ivy League schools, or we can choose to send our kids to HBCUs. How do we support? That's not to say that you can't, support in the Ivy League school, but I'm just saying we have to be conscious of the choices that we make. Do you send your kids to the public school in your neighborhood, or do you send them to elite private school where that will benefit your child, no doubt, but your child will be benefit and you will be benefit, and your community will be benefit if you have a more community focus and you do things that will benefit the community. So my first thing is to be conscious. My second thing is to focus on community, and really thinking about and emphasizing things that have been said before, especially with respect to Rose. Conviction. As Maya Angelou said, one person standing on the word of God is a majority. Don't be scared to be the only person out there calling what is wrong, wrong, and calling what is right, right. You can make so much more of an impact if you have a prophetic conviction that you tell the truth in your sphere of influence, and that you will have more impact on your life and others' lives by being convicted instead of going along with the flow, going along with the crowd. It's so important that there is a voice for diversity. There's a voice for inclusion. And many times that is missing. My hat goes off to the GC of HP, who said, if you don't bring diverse attorney teams to me, you're getting a haircut. And when you start hitting people in their pocket, that's really when it starts to get emphasized. And I agree wholeheartedly with Nancy that there is an obligation of the institutions to do things to advance diversity in arbitration. However, a lot, and maybe even more, arbitrations and mediations don't flow through institutional groups. They're ad hoc. They're placed among the old boys or who you know. And so there's got to be an emphasis from clients who the old boys were serving that say, I demand diversity on my case. I demand diversity of my arbitral panel. And I know CPR has even written a clause where you can write diversity into your arbitration clause. I don't know how many people have adopted it, but it is a start. It is a start. The other thing is that, my last point, and I will yield some of my time back to the floor. But my last thing is that, like Martin Luther King, I think we have to be eternally optimistic. We have to expect that things will get better, that things will happen that advance African American and the diverse community in general, and arbitrators and attorneys in specific. I think there are a lot of opportunities for people to do the right thing. And I encourage those who are in the position to make changes to do so, and those who are in the trenches like us to continue to put one foot in front of the other, knowing that if you hold on and you continue to trot forward, there may be some bad times, but your good times will outweigh your bad times, and you should not complain. So how long should this call to action happen? How long are we going to have to wait? How long do we persevere? I don't know. I think when I saw the Super Bowl this weekend and heard them sing, lift every voice and sing on the Super Bowl, I thought, wow, that was a moment. But our moments have to be more than songs. Lift every voice and sing till earth and heaven rings, ring with the harmony of liberty. Let it rejoicing rise high as the glistening skies. Let it resound loud as the rolling seas. Speak truth to power. Have prophetic convictions. Be conscious, become a conscious of your ethnocentricities, and continue to focus on community. Thank you.
Thank you, Lisa. Thank you for that. Thank you. Our next speaker is Thevenin Ejikwe. Thevenin Ejikwe is a barrister and solicitor of the Supreme Court of Nigeria and solicitor of the Senior Courts of England and Wales. He had an LLM in corporate finance law from the University of Westminster. He's an energy and natural resources expert and corporate and project finance lawyer. Thevenin worked in the UK for many years before relocating to Nigeria. He's a partner at the Law Crest LLP with offices in Lagos and Abuja, Nigeria. It's a pleasure to welcome Thevenin Ejikwe.
Thank you very much for that very kind introduction, Ijoma. First of all, to congratulate the American Society of International Laws Africa Interest Group for organizing such a momentous session today. I'll just say that it's a privilege and an honor to speak on matters that relate to such a significant personality like Martin Luther King Jr. I mean, anybody who, all over the world, wherever you were, who took an interest in anything would of course know of Dr. Martin Luther King. In fact, there are very few icons in the world who one could talk about. So I don't know, I think Martin Luther King ranks higher than perhaps anybody, but at least in the category of the likes of Mahatma Gandhi. And so all through development and growing up, one has admired Dr. King. So thank you for this privilege. It's interesting to have heard what everybody has got to say and the different perspectives that have been brought to the conversation today. And I've really learned a lot from what everybody's got to say. And it's interesting also that I appear to be the only one who practices from Africa. So I've tried to give an African dimension to the conversation. And the things I'm going to speak about would perhaps have been different if I was still practicing in London, a place I practiced at for about 10 years. So I'm going to look at, the principles of just the thing that Martin Luther King stands for. I'm going to look at the rights and wrongs and the modern notions of rights and wrongs and whether we actually even understand what rights are. So when we talk about civil rights, civil liberties, what do they mean? Do we still understand them? Or have our value systems been so eroded that it doesn't really mean anything to us, or we don't even know what it means anymore? I'm also going to look at the African situation. You know, when we talk about man's inhumanity to man, does it have to do necessarily with race or color, or is it a universal phenomenon that you could find anywhere? I'm going to look at the government as the catalyst of impunity and man's inhumanity to man. And then finally, I'm going to try to consider what a lawyer can do to advance the cause of justice, liberty, freedom, equality, and all those things that actually brings humanity together. So yes, Dr. Martin Luther King Jr. was about liberty, equality, and justice. And I think that these principles are universal. And if anybody studies Dr. Martin Luther King, you will find that he took a keen interest in things that happened in India, in colonial Africa, and in all parts of the world, and would not shy away from making a statement wherever he found that there was an unjust system or regime. And interestingly, he followed a system that was given birth to by, or made popular by Mahatma Gandhi. And that is a system of nonviolent protest against injustice and inhumanity. And truly, I think that it's quite telling that he lived at a time when there were other proponents of different types of agitation, like, for instance, Malcolm X, but that his story is so profound and it's one that resonates and we all aim to emulate across the world, truly signifies the personality and the person that he is. Now, going down to the issue of rights and wrongs, I think it was a product of the great enlightenment of the figure of Dr. Martin Luther King that he was able to so strongly identify the things that were wrong with society. And even though he had a bit of privilege and could have at least stood by and watched, he felt it was important to challenge those systems of injustice. And interesting point to note is that the location, and that's why I'm going to use Nigeria as a sort of case study for a conversation I'm going to have, is that the location determines the level of activism and activity that one engages in the defense of civil liberties, civil rights, or human rights. And so in Dr. Martin Luther King's time, it was a time when there was a lot of oppression and subjugation of people of color in America. But the question is, have those things changed? And if they have changed, to what extent have they changed? What roles did people like Dr. Martin Luther King play in changing legislation or affecting legislation or affecting the thinking of society at that time? The problem that I see today is that the world is so blurred in its vision and thinking that sometimes it's even difficult to determine what is right or wrong. And in a place like Nigeria, you know, you struggle sometimes to find people who know now what is right and what is wrong. So when we talk about civil rights, I just want to bring it down to what is simply right or wrong, what is just and unjust, what is fair and unfair, whether equality or inequality. So you find that for various reasons, we do not have people who have the consciousness anymore to think beyond themselves. So people only react when their individual rights are hurt. And it then means that you leave a lot of people in the lodge who have definitely nobody to speak out for them. And it then brings to question the role of the lawyer in the entire system. Now, you look at the African situation and the Nigerian situation, for instance. You don't have people of different colors. You have one almost homogeneous system in place, even though you have different tribes and ethnicities. But you still find that there's discrimination along the lines of tribe and ethnicity. And those things are questions that, of course, we ought to challenge, just as we challenge racism or we challenge any form of abuse of civil liberties. However, I think that the most prevalent form of oppression that you find in my own country is impunity at all levels, especially by government agencies. You find today, and I forgot to mention at the beginning that I'm the chairman of the governing board of the Institute of Continuing Legal Education in Nigeria, the Nigerian Bar Association. And through that agency, we do a lot of training and equipping and engage in a lot of dialogue with state agencies and you find that they are largely ignorant as to what their roles are. So the challenge for us here is that sometimes you find that there is we get reports every day of lawyers who are being abused in the course of their duties to their clients. So if you have that level of impunity, you wonder whether the lawyer who is not even able to defend himself can defend other people. Now, and this is the core of the matter. We've had, and we call it in Nigeria, public interest lawyering. So every government agency has big men in it, and people in government naturally, and this is a product of various iterations of administration and government in Nigeria. During the colonial era, you had the British, they were a big problem and they were challenged. From that era of authority, you had a short period of democracy, but then you had militarization. And the problem you have today is that you have a civilian government that still has a military mentality. And because of that military mentality, you have excesses of impunity and discrimination. And so you find that it is very challenging, and those who are equipped generally to fight these battles and challenge the system do not have either the time or the attitude to engage and to confront the system. So, and then but there is currently a movement, especially by the Nigerian Bar Association, to challenge all levels of impunity in government. We now have what we call a public interest litigation group that simply challenges the government through litigation at all levels. Unfortunately, even through the judicial process, we have systemic issues, sometimes confounded by the problems that you have of injustice, inequality, even within the judicial system, where you find that corruption sometimes affects the system and there is delay in the judicial process. So it takes as much as sometimes 10 years to get justice. So even when the Nigerian Bar Association is involved, you find that it struggles against state actors to achieve what it thinks it should achieve. But what we have been involved in doing, and indeed what I think that all lawyers must do, is that we must first remember who we are. And looking up to Dr. Martin Luther King Jr., he wasn't a lawyer, but I think that there's so much we can learn from him. That most of all, I mean, a lot of people who've spoken here have said they are arbitrators. I'm a commercial lawyer, for instance. So when I'm busy making money, I sometimes forget that my first calling is to be a lawyer, and that there are certain principles that we must espouse as lawyers. There are certain things that we must stand against. Our basic training means that any form of inequality, any form of injustice, anywhere that there's an abuse of freedom, we must fight aggressively against it. And you might just writing a letter to challenge something that is bad, writing an article to challenge an abuse of privilege, writing, speaking out against any form of injustice is enough. And we must do that. We are equipped, whatever specialization that we have, to employ the tools of litigation, to employ administrative law tools like judicial review, mandamus, certiorari, and all those other skills that we acquired whilst growing up, to challenge things that are even beyond our immediate sphere of influence. I think that the battle for equity, equality, justice, freedom, and liberty is one that has lasted a lifetime, many lifetimes, all through history. And I do not think that that battle will stop. But I think that if there's a chance to create a new world order where peace, harmony, freedom, equality, and justice would reign, then the lawyer must be the catalyst of that change. Thank you very much for your indulgence. Great opportunity to speak to you. Thank you.
Thank you, Thevenin. You made a very valid point. The point of speaking out, that's what one of the things Martin Luther King stood for, and that's just true. Thank you for that. So we've come to the end of the first session. The next session will be an interactive one where we all discuss, discuss some of the points raised. There are so many points raised here. However, some stood out. Rose's point on the 6 nonviolence stood out for me. I'm sure lots of things stood out for other people, but the 6 nonviolent points, the 6 Martin Luther King principles stood out for me, which I'm sure resonates with every other person. Let's deliberate on that. As well as Rose's point on developing consciousness and the community. These are very important points. There's so much to talk about, but at this point, let's get into an interactive session where we can discuss some of these points raised and possibly discuss for the next 10-15 minutes, then open up the floor for attendees to raise their questions and make comments. Thank you. Chris, could you kickstart this interactive session, please?
Well, sure. It was my pleasure to kick off this conversation. And now, as someone said earlier, it's difficult to follow all those great words by my sisters and my brother here over the last hour and some change. So I look forward to welcoming some questions. If we're waiting on them to come in, if they are coming, I think that we can more or less just talk amongst ourselves, I suppose. I wonder.
Yeah, let's talk about amongst ourselves. Yes, please. Yeah.
Okay, can do that.
Can I make just a slight correction? The community call, it was my sister Lisa who beautifully put it, the consciousness of the community call. I think she
yeah, I said Lisa. Didn't I say Lisa? Did I say somebody else?
I thought you said Rose.
No. You made a point on the 6 principles of Martin Luther King. Okay. She made the point of consciousness and community. Yeah.
Yes, that's what I wanted to say. Yeah.
No, I was waiting for that piano to cut in when Lisa started quoting "Lift every voice and sing." I said, "Okay,
yeah,
all right." We already had we had the scripture, we had the piano going. It'd have been a good time.
Beautiful. Now, can I say something regarding the nonviolence, for instance?
Yes, please. Yes, please.
I think oftentimes many want to just put MLK, Martin Luther King Jr., at the same level as Gandhi. I am personally, I feel it's actually a little bit offensive to Martin Luther King. Let me explain why. Martin Luther King went to India. When he got to India, he realized that the Indians have a caste system where people like us are at the bottom and we stay there. And instances, they won't even touch you because you are caste. Martin Luther King did not believe in any form of discrimination. He was really about unifying all people. So for me, even when I look at Gandhi's work in South Africa, and I'm happy to say that they have removed his even statue in Ghana. So for me, as a Black person, when I see Gandhi, I can't stand there because I have read so much about him. Yes, he was nonviolent. I'll give to Caesar what's for Caesar, but the rest of it, MLK tops. So that's how I'd like to break the discussion. So educate me if I'm wrong, please.
No, I think
you're right.
Please
go ahead. No, go ahead. No, you go ahead. I'm just supporting her. Yeah, go ahead.
No, I was only going to say that I think that for sure, Gandhi has many things that are somewhat controversial in his past, and I think when it comes to the example and the principles that we're talking about today, one of the things that I wanted to sort of emphasize was that, especially in the American context, we do kind of find ourselves being thrust forward by the momentum of the actions of a lot of the civil rights leaders, and those of them that are still with us today, of the work that they did. But unfortunately, evil never sleeps. And there are many people that continue to try and chip away at those things. And so that's why we have to be the vanguard against them, even if it's only 4.7% of us that make up the American legal population. If we don't do it, the community itself does not have the same level of training when it comes to dealing with legal battles, and it's just not an equitable fighting field. So that's something that we must do in order to make sure that our brothers and sisters are not left exposed.
Thank you, Chris. I have a question. I have two questions, actually, one for Lisa and the other for Thevenin. So the question for you, Lisa, is, and thank you everybody for these wonderful presentations, including quoting some amazing songs, very uplifting, hopeful, and encouraging. Lisa, how do we combat this idea that, we talked about the opposite of the affirmative action, like, okay, if you guys start focusing on your race, then, what Chris sort of mentioned, the critical race theory, the, upside down, if you guys start focusing on your race, how are you being equitable? This pushback, Chris talked about Black love. We have a need for that in the US of A, because I think a lot of the problems that we suffer from is self-hate, stems from self-hate. And that is not just coming from us. It came from somewhere also to teach us not to like the color of our skin or the textures of our hair. But when we try to get together to form a community in support of each other, then Blacks are accused of being racist and inequitable. I want to know from you, specifically, Lisa, and from everybody else, how do we respond to that? And then Thevenin, the question for you has to do with this. Studies have shown that corruption prevents a country from prospering, period. It prevents them from being internationally, competing internationally with their neighbors. Is there a movement in Nigeria to focus on that by the business community at the very least, or the population in general, to show that the less corruption we have, the more prosperous the country can be, the more prosperous its citizens can be? So those are two separate questions, and I'll take the first one.
So I guess to the first one, I would say that I think one of the biggest problems are the rules change when they start applying them to us. And I think the most recent example of that has been the movement toward trying to have the first African-American woman appointed to the Supreme Court. And so now the focus is that it's racist to say that there should be an African-American woman on the court. And the problem with that is that when it comes to African-Americans and diversity, the rules change. It's okay for there to have been, I don't know, what did they say, 78 white males who have been on the Supreme Court. It was okay to say that we should have a white woman on the Supreme Court, and no one cried foul, and no one cried racist, and no one cried affirmative action. But when you look at it being an African-American, then all of a sudden it becomes a problem. And so I think the biggest thing for us to do is we have to change our frame of reference. We have to change our consciousness. It cannot be okay for years and years of exclusion to be the rule. And then when we try to make some inroads to try to turn the tide even slightly regarding that exclusion, that it's now us stepping on they pull affirmative action card and say that that's something bad. I say that, when we talk about, as I said before, affirmative action, when you have literally have your foot on somebody's neck for 12 generations, there has to be a whole societal change. And there has to be a whole consciousness. And there has to be a consciousness that's not just about me and mine. There has to be a more global, a more humanistic look at how we as a group strive and succeed. And I think that's the biggest problem with a lot of people, that they cannot get out of their own way, their own frame of reference. And that's why I emphasize the need that there has to be a new consciousness. There has to be an extended consciousness to understand the historical underpinnings of the discrimination that has happened to diverse people. And there has to be a desire to turn the tide and the trend.
Mm-hmm. Thank you so much, Lisa. Anybody else want to address that question?
I would just say, you know, in the comment to the Supreme Court, Thurgood Marshall, how the heck did we replace Clarence Thomas by Thurgood Marshall? And I'll say sometimes what we see in our society, even in the face where they want to have a diverse group, for some reason, they want to have a certain type of Blacks, a certain type of Black woman, a certain type of Black man. And I think that a lot of times what we as a community, to piggyback on what Lisa said, the community, is to be aware and do our research. A lot of diversity initiative, but they are not doing their research. And when you don't do your research, I may keep quiet because I pick my battle, but I see, and I know I'm not the only one who discuss these things. We see it, we're like, wow. It's almost as if like they just want to just push something, push an idea. George Floyd, anything. So I think that we need to hold them accountable. And that's why I said in the principle to allow them to be rehabilitated, but we must call them out too. Won't let you get away with it. We'll tell you and give you an opportunity to come clean.
Right.
One of the biggest beneficiaries of affirmative action have been white women.
That is true. And I think one of the things that has been on my mind a lot over the past year, following a pretty outspoken GC over at Coca-Cola, who was basically demanding certain metrics for the law firms that they would work with on their legal matters, was promptly replaced after having very high standards for diversity and wanting to show some actionable and accountable progress. And I think that, well, that's sort of what we need too. With any of our businesses and any of our functions, if we had goals that year after year we weren't meeting, if we had metrics that we needed to hit and they just weren't being met after time, none of us would long be in that job. So similarly, and this is for myself doubly as an in-house counsel, my goal and my job is to make sure that that diversity is seen in the counsel that we choose and the neutrals that we have as well. And I think that's what we have to demand from these organizations that we're a part of, because they certainly won't demand it for us.
Right. And in response to that, I mean, I have the privilege of serving at Icc USA and being part of the selection of arbitrators, at least the discussion. And one of the things I've learned is that thinking about diversity is a purposeful act, because especially when you come from an industry where we all know who the stars are, we all know who the people are, you know, who have the resources to market themselves, be it, you know, big firms, whatever it is, it's not often a diverse person, whether you're talking about gender or racial or ethnicity. So you need to think about it. And I think, you know, the ICC has this thing with the selection where you cannot pick the same person within a 12-month period. That really helped. That little rule that said, you cannot select, the ICC cannot directly appoint somebody within the same person within a 12-month period, except under exceptional circumstances, forces us and all of the, you know, ICC national committees to say, okay, we got the star for this one. We want him to serve again on this one because we know he'll do a great job. But no, you have to think about somebody else. Who else can you think about? Expand your horizons. And now they mandate that the list be diverse. You know, we purposefully worked to make sure we got, gender diversity. And I think we need to purposefully work to make sure we have racial and ethnic diversity. I've seen it. That is the only way it works, because otherwise you're going to keep doing what's comfortable. You know, you're going to keep going with what you know works, and you're not going to take a chance, take a risk, or give anybody an opportunity. I find that mindset of why are you purposely thinking about race, isn't that in and of itself discriminatory? It's simply not true. That's my experience. But anyway,
Savan,
yeah. Savan and corruption, if you don't mind helping me understand, if there's any understanding in Nigeria, how damaging corruption is to a successful, thriving nation economy.
Thank you very much, Nancy. I mean, I think the issue or the topic, anything around corruption, is something that we can talk about for a whole day. And I think it's important to make the point that if we are honest, we would realize that it's actually a universal phenomenon.
It is.
And the more you listen to the news, the more you hear a lot about certain underlying factors or issues around corruption that actually make you struggle. And they go to the fundamentals of some of the issues we've discussed today around justice. And I think it was Eunice who mentioned the factors around social mobility. And those are big things that actually border on issues around corruption. But getting down to Nigeria, I think that corruption is not as big an issue as lack of purposeful governance is. I also don't think that it's as big an issue as consequence management and the ability to punish for corrupt activity. So I think that it's actually a segment of the society, as is the case in most places in the world, that actually have the power or the ability to be corrupt. But unfortunately, where we talk about impunity, where the government there's crass impunity in a system, it then becomes difficult to regulate the corrupt forces. Because if the powerful are actually the ones who are corrupt, then it then becomes a problem. And when I was speaking, I had mentioned about rights and wrongs. And you see, where the line becomes very blurry about what corruption is. And a system that refuses to reject anything that is abusive or wrong or dirty, then begins to accept certain things as a norm. So the real problem you then have is that the people then struggle with the notion of what is right and what is corrupt. So yes, and then the last question, the last point you asked about was whether there are movements or any movement in Nigeria to challenge corruption. Impunity is a form of corruption, a serious one. The Nigerian Bar Association is at the vanguard of challenging all forms of corruption, all forms of inequality, all forms of impunity through the legal means and by speaking out generally. There are also many civil liberties organizations and corruption-based NGOs who fight. And there are individuals who always speak out about corruption and actually challenge government agencies and individuals who are corrupt. We also have certain judicial officers who are very activist against corruption. I mean, I was a particular judge that delivered a 9-hour judgment against a certain corrupt individual. So yes, I think we in Nigeria truly understand the challenges around corruption. And there are those who believe that it would actually, the corruption sets any society back, whether it knows it or not. Yeah. So I hope I've attempted that question.
That's right. Thank you. It does.
Yeah, I guess we have 10 minutes to go, or less than 10 minutes, because I'm conscious of people's time. This question is for Eunice. Eunice, you did mention that whether we are extremists, but what kind of extremists are we? Is this with regards to lawyers? Or are you talking about the community in general? Could you please clarify this position you made earlier on? This question is for Eunice.
Well, good. So the question is whether we're extremists in general or whether we're extremists as lawyers.
The question is this with regards to the lawyers or is this with regards to the community in general? I'm just trying to get some clarification there.
Right. I would say it's with regard to both, because the two forms of extremism that Dr. Martin Luther King was talking about, which I was reading about in his letter from Birmingham jail, was that we can either choose to be extremists and be quiet. So basically, we're just being quiet where injustice is going on, or we can be extremists where justice is going on. And justice, yes, it's for us as in the legal profession, but I think any fair-minded person in the community can see where there's injustice, and it's behoves upon each of us to actually say something. It's when that's the phrase, the saying that goes that all we need for justice to flourish is for good men to say nothing, and that's it. It's literally, so I believe that, yes, we're talking about the modern lawyer, but it behooves all of us as a community to be extremists and speak up for justice wherever.
I would imagine extremists with non-violence, though, because it could be
absolutely, which is why I said speak up. Yeah, and so that's the way it is.
And possibly the pen, I would imagine.
I'm sorry.
Yeah, I would imagine you mean using your pen and your mouth to speak out.
Speak exactly.
Out verbally as your pen.
Yeah, to speak up. And not just be quiet, because half the time the battle is people being quiet and pretending that they actually have not seen what is really blatant, or even worse, trying to defend the indefensible, which is even worse. Yeah.
Okay.
Which I would add is exactly what we've seen in this Brian Flores situation. Some of you that I was having a conversation with will recall this that I raised. It's an NFL coach that has patently, openly been discriminated against on the basis of the color of his skin. And simultaneously, you have some Black former players and former Black coaches that are like, oh, well, the NFL is great. I never had a problem. As if that is an excuse or that is somehow an obfuscation of the issue at hand.
My brother, you are so right. It goes back to, I'm sorry, Nancy, it goes back to one of the principles, some people would rather stay quiet so that they feel comfortable and they don't want to offend and they stay in the club. So Nancy, go ahead. I'm sorry.
No, fine, please don't apologize. I am not a sports fan. It always seemed very odd to me that human beings could be traded. The NFL, looking at the NFL, is there are serious issues there. And in researching for this panel presentation, especially in Martin Luther King's latter years, he really was what we would call radical and extremism against injustice. And he was putting a glaring light into poverty, the lack of opportunities and education did to a whole generation. One of the things he talked about was African Americans not only loving themselves, but supporting each other, and through nonviolent means, making our voices heard, right? So one issue is he believed in our political rights, and that is the right to vote, our political power, right? Through the right to vote, which right now in the US is being eroded incredibly fast. But the other thing that we have is, as in talking here about African Americans in the US, I think there's a potential for all businesses to make about, I think there's one of those business service, about $300 billion from African Americans. African Americans make about the second biggest group of consumers in the US. One of the things Martin Luther King said, you want to protest something, you do it with your dollars also, not just with your voices, with voting. And I I enjoyed halftime at the Super Bowl. Yeah, I'm one of those. I'm one of those. I couldn't care less about the game. But there were a lot of participating African Americans there for a league that refuses to see the benefits or the value of African American players. So, not to say anything too crazy about the NFL, except for what I observe as a non-sports person. It was very interesting to see how many people were giving their dollars to this cause when it was glaringly obvious that there was a problem with it. Now, you juxtapose that with the whole thing of let's talk about the problem, not the person, right? That you mentioned, Rose. Let's attack the problem, not the person. But Martin Luther King did say, you should be able to protest. You protest with your vote, with your voice, you protest with your dollars.
So just to butt into that, I think that, one really has to think deeply about this comfort zone phenomenon. It takes a high level of enlightenment to achieve the two things that Dr. King achieved so apparently seamlessly. On the one hand, it is the understanding of what is wrong and societal ills and being able to challenge. On the other hand, it's actually is a non-violent element to it. It appears just on the face of it, a contradiction of ideas to challenge an unjust and potentially destructive system through non-violent means. So I think that just speaking truth to power can cause you a lot of damage. And in Dr. King's case, it cost him his life. And anyone who lives in any oppressive society will realize that it takes a high level of enlightenment to be in a position to put yourself in harm's way and to put yourself at risk and indeed to pay the ultimate price. But society can never advance unless human beings elevate themselves to that point where the comfort zone phenomenon is thrown into the garbage can. Thank you.
Well said.
Thank you. No, thank you. Thank you. That was good.
Any questions from the public?
I think EJ has dropped off the call. Maybe that's why the questions from the public have not come through.
Well,
I have a question. Sorry.
Just one correction for the record about the number of Supreme Court justices that there are.
I saw that.
Yes, so there have been 114 and 108 have been white males.
Yeah, and I'm going to check out.
Got it.
Yeah, I'm going to check out the Colin Kaepernick documentary.
I'm conscious of time at this point. We have 5 minutes to give our closing remarks. So we'll start with the lead speaker, Chris, in the same order. Let's all have our closing remarks ready and can get ready to wrap it up. Yeah, Chris, please.
I think the only comments and the only things that I would say and urge is that we all remember that time and life are unfortunately very short and very fragile. So we must make the most of the time and the opportunities that we have and not wait for some mythical top point in the future when these things will be the right moment to happen. The time for action is now.
Nice one, thank you. Eunice, please.
Yes, I would agree with that. The time for action is now. And the other thing I would say is that it's not an option for anyone to be quiet and to defend the indefensible. If there's something that's wrong, speak up.
I think this is me now, right?
Yes, please. Thank you.
I think that my call for action would be to really seriously stand by the way that Martin Luther King say you must be courageous. Nonviolence is a way of life for courageous people. So my motto is see or hear something wrong, do or say something right. Stop sitting there and say it's not my problem, because it is your problem. When your neighbor's house is on fire, if you don't go and help turn down the fire, pretty soon it'll get to yours.
Thank you. Yeah. Nancy, please.
Oh, thank you. I would echo the comments of the previous speakers, all excellent. The call to action is, and I love everything that was said, be conscious, look around you, see what's happening, get involved. We can't afford to stand on the sidelines. Get involved, do something. It doesn't have to be huge. Like Chris mentioned, donating to organizations that are helping with social justice, and maybe doing a scholarship. Just get involved, help us. This is a huge lift, and we all need to do it together. Thank you.
Thank you. Lisa, please.
I'm going to mix a little philosophy and scripture. Rameau, and I urge everyone to do this. If one advances confidently in the direction of their dreams and endeavors to live a life they have imagined, they will meet with success unexpected in common hour. Coupled with the scripture, now to him who is able to do exceedingly and abundantly above all that we could ever imagine or think, according to the power that works in us. To him be glory.
I love it.
Amen.
Lisa, are you a preacher? You must be a preacher.
I love it.
Yeah,
She
thank
must
you
be a
very much.
preacher.
Imagine and pray. That's what it says. Dream and pray. Dream, pray, and work.
You must be a preacher. Thanks for that. Thank you.
Yeah.
Thevenin, please.
Thank you very much. It's been a very engaging session. I think that the consensus around the fact that the issues around liberty, justice, and freedom they're universal, and they've been there all through the ages. And again, consensus on the thinking that the lawyer should actually lead the charge in creating a better society. I would leave us all with a challenge, and that's a challenge from an Algerian author called Dr. Frantz Fanon. Frantz Fanon said that each generation must, out of relative obscurity, discover its mission, fulfill it, or betray it. And the big issue is, as far as civil liberties, as far as freedom, as far as equality is concerned, what is the mission of this generation of lawyers? Are we willing to fulfill that mission, or are we going to betray it? Thank you very much.
Thank you. Thanks for the good one. Thank you. We've come to the end of this session. Thank you, everyone, for making time to join the African Interest Group for this informative and worthwhile time. Eunice, do you want to take a picture of all of us? You know, you mentioned the picture. Do you want to take it now? I don't know how to do it. I just don't know. So I can't claim to know what to do. So you tell me. You do it. Go ahead and do it. Take a picture of everyone.
I have actually done it once, but I'll do again. So everyone ready?
Yeah.
Okay. Yes, hopefully we're done. Let me just check. Yeah, it's come out nicely. I'll make sure I circulate it to everyone. Thank you very much.
Thank you very much. To Asiel, a very big thank you. To James. James, thank you so much for all the support and all the assistance. We're really grateful. To everyone who made our time to join the African Interest Group, I say a very big thank you. To you, Chris, to you, Eunice, to you, Nancy, to you, Rose, to you, Lisa, Thevenin. Thank you very much. I've enjoyed the session. Thank you so much. Thank you, everyone. Thank you, and have a wonderful evening, afternoon, wherever you are in the part of the world. Bye, and thank you once again.
Bye, everyone, and thank you.